Los Angeles County Deputy Public Defender Philip Dube. Philip, great to see you again. Thanks for being on the show with me tonight. And you know, what's interesting is, and just from the little bit that we watched there, we've got, you know, quite a few folks being struck for fixed opinions. And I'm finding that's becoming more and more common. What are your thoughts on that?
Well, during jury selection, anybody who has a fixed opinion, it really means they're biased. That means they're swaying one way or another, and they're not supposed to. I mean, that's the whole point of voir dire, is to make sure that you get impartial, objective people. And if they already have a fixed idea of how they're going to, you know, ultimately render their verdict, that you don't want them because they haven't heard one iota of evidence. All they're doing is basing it on maybe what they're observing in the courtroom during voir dire, or maybe what they're reading on the internet, or what they're watching on television. But nothing is sworn from the witness stand. So yes, it is absolutely a problem, but that's why you need voir dire. This is why you need to really drill all these jurors, and hopefully they'll do it thoroughly so that they get the ones that have that actual and implied bias kicked.
You know what's interesting, Philip, and I just want to say this. I think there are some savvy folks out there as well who can use the whole fixed opinion thing just to make sure they're not on the jury. They know that's almost an automatic way for them not to have to serve. There are plenty of people out there who may show up but really don't want to serve.
I got to tell you, Michael, there's a lot of judges who wouldn't care if a juror said that. They'd keep them anyway and not use for cause challenges and let the lawyers use their peremptory challenges. They're limited. You know, listen, with judges, oftentimes outside the due process concerns, it's all about judicial economy. They don't want to burn through endless jurors and pay all these people and keep them coming in. At the end of the day, courts are a business. And sometimes even in government, it does boil down to dollars and cents. And sometimes judges are quite parsimonious. So that plays into it as well.
Yeah, I have to agree with you there. But I think in this particular instance, it's fair to say, and I've noticed that Judge Walmsley has been very liberal with his striking of particular jurors. And I think, and you mentioned, you know, states, the courts, they're all businesses. And I think part of running a business is public perception, which is one of the reasons why cameras in the courts are so important. And I think he wants to make sure that this thing is as clean as it can possibly be so that it's immune from any type of obvious appeals and things of that nature. Do you agree?
Yes, and also he doesn't want to send a message on national TV that you can get out of service so easily. You know, he wants to let the public at large know that, look, if you're coming at least to my courtroom to serve on a jury, you're not going to just be able to come in here and tell me you have fixed ideas about the evidence. We want to really delve into that and find out if that's true. Because yes, we do have these stealth jurors, the ones who don't want to serve versus the ones who are trying to get on the jury.
Yeah, what was interesting, Juror 178, the arguments there I found interesting. I'm not sure, maybe there was an underlying reason, but as you heard there, Greg McMichael's attorneys wanted to get rid of 178. She was 18 years old. They basically said, you know, they didn't know if there were any kind of mental issues, but they felt she was very immature. She was clearly nervous, couldn't answer simple questions, seemed evasive. I want to get your thoughts on that type of judge. The judge made very clear, she's 18 years old. I didn't see any particular problem. She might have been a little nervous, but she made clear that she could deliberate, express her opinions. I want to get your thoughts on that.
No, certainly that would be grounds to exercise one of your peremptories, to get rid of somebody who you don't think is really going to go your way or might not even understand the evidence, not because they are, you know, illiterate or anything, but they just don't have the you know, the world view, the world experience that you would have, the life experience that you would have if you were maybe in your 30s, your late 20s, or even your 40s and 50s. But at the end of the day, this judge ruled correctly, in my opinion, because she did not demonstrate an actual or implied bias. So therefore, there was no grounds for a for-cause challenge.
Yeah, I agree. And again, remember, it's about for cause, it's about peremptory. So she's just not removed for cause. If one of the attorneys feels like she's not the right person for them, they can use, of course, a peremptory strike. Is she someone you might want on the jury, someone like that, immature, someone who may not be as savvy or have as much life experience as some of the jurors in this particular case?
No, because she seems like the type of juror who could probably be bullied by one of the more outspoken jurors. You know, sometimes you have those jurors who are, I don't want to necessarily call them bullies, but I call them leaders. You know, they kind of take charge. Maybe they make themselves the foreperson, and then they kind of roughshod fellow jurors into just giving in to their view of the evidence. And sometimes these young ones are just too immature to stand their ground and have a mind of their own. Unfortunately, under the law, it's not grounds to excuse a juror because it's not an actual or implied bias. Now, if she were selected and they were deliberating and they passed a note to the judge saying, you know, there's a juror in here. We don't think she's got the smarts or the intellect to understand what's going on. She won't participate. Well, then you hold a hearing. Because at that point, if she is a sworn sitting juror and she is not performing her sworn duties, the judge then can excuse her for cause.
Ah, great points there. I didn't even think about that, but you're absolutely right. And that's why they have the 4 alternates in a case like this. They would just swap her out if in fact they found that that was the case. All right, Philip Dube, stand by. We're going to take a quick break right now. As you saw,